Well, good afternoon, everybody. I'm Mark Agrasti. I'm the Executive Director of the American Society of International Law, and I bring you greetings on behalf of our membership, our President, and our Executive Council. Most of you, I think, are familiar with us, and many of you are members of the Society, and you know that it is a nonpartisan educational membership organization founded in 1906 and chartered by the United States Congress in 1950. Its mission is, broadly speaking, to foster the study of international law and to promote the establishment and maintenance of international relations on the basis of law and justice. Those were the words of our first president, Elihu Root, who was, as most of you also know, the Secretary of State in the Theodore Roosevelt administration when we were founded. Its 4,000 members include lawyers, judges, diplomats, and academics from over 100 countries. The Society has been honored to co-sponsor these dialogues since their inception. These annual gatherings are among the many ways that we try to fulfill our mission and to renew it. I think nobody here today needs to be told that that mission has taken on increased urgency and importance in light of current political realities in the U.S. and in other countries. And we are pursuing our efforts to educate on policy and to educate on international law with, I would say, renewed vigor. Now, as part of our contribution, as Jim mentioned, the Society does publish the annual proceedings, and I'm pleased to share with you that the 10th proceedings of the 10th International Humanitarian Law Dialogs have just been published and are available for purchase. We've got some copies here, but the best way to purchase them is online for $25 if you're a member of the Society and $35 if you're not. And we are hopeful that this special edition is going to be widely disseminated. It's a unique record of the ceremonies and the keynote speeches, the discussions, the dialogues that took place in Nuremberg last year to mark the 70th anniversary of the closing of the International Military Tribunal. I would like to express our appreciation to my co-editor, David Crane, and to the managing editor for this volume, Molly White. We have flyers outside and we have display copies on hand today. And Molly, are you in the room? Where's Molly? There she is, right at the front table. So she can assist you, and she will have complimentary copies for all of our sponsor organizations and for all of the speakers who participated in the Nuremberg sessions. And I also hope that those of the prosecutors who were not at the Nuremberg dialogues but are here today will also pick up a copy before you leave. It's now my honor to introduce our luncheon speaker. Andrew Cayley, who many of you have already met, of course, he's been with us since we started yesterday, is the Director of Service Prosecutions for the United Kingdom. He previously served as a British military prosecutor assigned to the International Criminal Tribunal for the former Yugoslavia, and from 2001 to 2007 as a senior trial attorney with both the ICTY and the International Criminal Court. While at the ICTY, he investigated and prosecuted a series of major cases, many of which have figured prominently in these dialogues over the last few years, including the Rajic case, the Kirstich case, the Talic prosecution. He was responsible for bringing the case against Ratko Mladic, that is now nearing completion, as we heard this morning, and led the first prosecution of members of the Kosovo Liberation Army. At the ICC, he was responsible for the investigation and prosecution of serious violations of international humanitarian law in Darfur, and filed the first case for war crimes and crimes against humanity in the region. From 2009 to 2013, after leaving the ICC, he was the international co-prosecutor of the Khmer Rouge Tribunal, formerly known as the Extraordinary Chambers in the Courts of Cambodia, from 2009 to 2013, which in fact he discussed on last night's panel with Nick Kumjian and Robert Petit. Andrew was appointed Queen's Counsel in 2012 where he is a governing bencher of the Inner Temple. He was awarded the Companion of the Order of St. Michael and St. George in 2014 for services to international criminal law and human rights. So given the breadth of his experience, Andrew could really have held forth this afternoon on any number of the subjects with which these dialogues are concerned. But he's chosen to speak today on the complex challenge in which he is currently engaged. The UK, Iraq, and the International Criminal Court, the domestic investigation of war crimes, and the role of the ICC. Just by way of brief background, as director of the UK Service Prosecuting Authority, he's responsible for providing legal advice to the Iraq Historical Allegations Team that was established in the United Kingdom in 2010 to review and investigate allegations of homicide and abuse made by Iraqi civilians against UK Armed Forces personnel operating in Iraq from the commencement of coalition operations in 2003 until July of 2009. Those allegations are also the subject of a preliminary examination by the ICC. These cases have presented extraordinary challenges to the investigators and prosecutors. They've had to contend with many factors, some of which will be familiar to this audience from other cases, including the lack of evidence, the unavailability of witnesses, and the lengthy passage of time since the events took place. In addition, they've had to take into account a number of unique circumstances, including the views of the British press and public of a deeply unpopular war, and recent revelations of attorney misconduct that have cast serious doubt on some of the original allegations. We're fortunate to have Andrew with us today to help untangle all these complexities and to offer his reflections on how investigators and prosecutors can overcome obstacles to reach a just result. Please join me in welcoming Andrew Cayley, QC.
Just preliminary matter. I'm going to speak at a level. We've got some high school students at the back, so forgive me for perhaps talking at a level which many of you will understand. But I think if I speak at a high level, they're not going to be able to join in this, and I think it's important that they understand this more than us in many respects. Some background before I start showing you these slides. I was approached at the beginning of 2013 by the UK government to consider applying, along with a number of other people, for the position of the Director of Service Prosecutions. At the time, I was doing the job that Nick Kumjian's doing. I was the international co-prosecutor in Cambodia. And I was approached completely out of the blue for this position because I hadn't actually really considered doing it. And there's quite an interesting background to the position. So it uses this phraseology, Director of Service Prosecutions. In 2006, the British government decided that it would rationalise the way that members of our armed forces are prosecuted. Prior to in fact, when the Act came into force, which was 2010, we had three separate prosecuting authorities, one for the Army, one for the Navy, and one for the Air Force, all headed up by very senior members of those armed forces, so an Air Force lawyer, a Navy lawyer, and an Army lawyer. And we had been, as a country, subject to a number of cases that questioned the fairness of our proceedings before military courts. The perception was that the chain of command within the armed forces had too much influence on the decision-making process. Historic reasons for that. I know, talking to US colleagues, this is also being questioned at the moment, where senior officers were able in the old days to squash a case, so they might have no legal qualifications at all, but they simply decided the case wasn't going to be prosecuted. So in 2006, the government decided to unify the three authorities, so there would be one prosecuting authority for the Navy, the Army, and the Air Force, and there would be a civilian head. There would no longer be somebody in uniform. The first prosecutor was a guy called Bruce Holder, QC. I'm the second person, and the reason for that was to ensure that the individual who occupied the position was completely independent of the military chain of command. There wasn't any influence. He or she was able to take decisions independently on who to prosecute. Now, I came into this job not in my wildest dreams believing that I was going to be still dealing with war crimes. In fact, one of the reasons I took the job was to get away from it and go back to domestic law and work, in a domestic setting again with independent judges, proper functioning legal system, all of those things which I'd taken for granted in my country until I went to Cambodia. Now I appreciate them very much. So that's the background to how I got involved in this. The allegations arise out of the war in Iraq, which, as you know, both the UK and the US participated in that war, the Second Gulf War. Coalition forces entered Iraq on the 20th of March of 2003. Major combat operations came to an end very, very quickly, much more quickly than anybody had anticipated. Subsequent to that, the US and the UK became occupying powers under the Hague Regulations. Article 42 of the Hague Regulations, for those who are interested, Common Article 2 of the Geneva Conventions. Now, that concept of an occupying power is extremely important. It was important from a prosecutorial sense because the grave breaches provisions, as you know, of the Geneva Conventions continue to apply during a period of occupation. So all of those provisions, all of the war crimes that apply in international armed conflict applied during that period. Now, granted, these days the war crimes both in non-international armed conflict and in international armed conflict are similar, but there was a perception of the nature of the role of the UK and indeed the US as being an occupying power, the duties and obligations that rested upon it. Now, the Coalition Provisional Authority was created, the UK and the US were both members of that. That effectively was the military government of Iraq. The UK was responsible for maintaining security and supporting the civilian administration in the southern Iraqi city of Basra. 2003, the Governing Council of Iraq is established, and then in June of 2004, the Security Council passed a resolution 1546 in which it transferred the authority from the UK and the US as the occupying powers to the Iraqi government. So the occupation ends, but British troops remained until 2009. In fact, the ICC reports, if you read their reports, they say 2011. Actually, most of the troops had left by 2009. Some troops remained. Now, we were there for a period of 6 years, and the allegations against UK forces arose in quite an unusual fashion, at least most of them. And I want to reiterate, the army was policed in Iraq during this period. It's not that much later we decided to investigate these crimes. Many of these episodes were investigated at the time. Those that weren't, you'll understand why they were not. Now, the principal source of the allegations against UK forces come from civil complaints. So Iraqi citizens who made complaint under the European Convention on Human Rights in both UK courts and before the European Court of Human Rights. Now, you ask yourself the question, why did the European Convention on Human Rights apply in Iraq? Well, generally, it has territorial application. So if you sign and ratify that treaty, the human rights, the basic fundamental human rights in that document apply in your territorial space. But the European Court of Human Rights, based in Strasbourg, which is the final arbiter of this convention, decided that since the UK was in occupation in Iraq, it had control and authority over Iraqi citizens, so the convention applied. And a number of Iraqi citizens brought claims against the UK government for breach of those fundamental rights that are contained within that document. The right to life, prohibition against torture, the right to liberty. So they brought civil claims within the UK courts and before the European Court of Human Rights, claiming that their fundamental human rights had been breached. And many of those allegations also constituted criminal complaints. So not only were they complaining about a breach of their human rights, but the complaint that they were making was that, in fact, that complaint was, in fact, also criminal conduct that we were obliged to investigate. Now, the potential offences do look very serious, don't they? Murder, manslaughter, grievous bodily harm, rape and sexual offences, and war crimes. Now, just to explain why I've put domestic English offences up there as well as war crimes. Under the Armed Forces Act 2006, which governs my role as the director, it governs the role of my organisation, the Service Prosecuting Authority, the criminal law of England and Wales applies to service personnel wherever they are in the world. And I think the Uniform Code of Military Justice of the United States is very similar. Now, there are reasons for that. That's to do with our colonial history as a country, that we often had members of the armed forces based all over the world. So, for example, when we had a significant number of troops in Germany, in the Federal Republic of Germany, after the end of the Second World War, they were subject to English criminal law. Now, the Germans actually could try them, but generally speaking, they operated what was called a waiver, and they said to the military authorities, no, you try them in your military courts under English criminal law. So, when we were looking at allegations against UK forces in Iraq, we could look at our suite of criminal offences under English criminal law: murder, manslaughter, grievous bodily harm, so serious violence under the Offences Against the Persons Act 1861, rape and sexual offences under the Sexual Offences Act 2003, and then, of course, war crimes: murder, unlawful killing, torture, inhumane treatment, cruel treatment, outrages upon personal dignity, also rape. Now, the Rome Statute, which is the governing statute of the International Criminal Court, is incorporated within our domestic legislation under the International Criminal Court Act. I think it's 2001, I haven't put the date in there, which means that we can try offences domestically in the UK that the International Criminal Court can try. Now, this goes to the heart of this concept of complementarity, which is that the International Criminal Court's basis of jurisdiction is first that domestic countries. So the member states themselves should investigate and try these offences, these war crimes offences. And the International Criminal Court will only intervene where the state is unable or unwilling to investigate and prosecute these kinds of crimes. And of course, as a country that claims to have the rule of law and a fairly developed legal system, our claim is that we are able to investigate and, if necessary, prosecute these crimes. Also, to mind, we've had to have this concept of command responsibility, which is a unique principle of responsibility within international criminal law. It is essentially where, simply put, I mean, it is more complex than this, but where a commander fails to prevent or punish crimes by those under his command, he can be held liable under this concept of command responsibility. So we also had that in our mind. Now, interestingly, we received nearly 3,500 allegations. That's, when I started, it was several hundred, but it got to 3,500 allegations, mostly as a result of individuals making civil complaint that their human rights had been breached or abused by British soldiers in Iraq. To date, 70% of those complaints on a criminal basis have been dismissed for lack of evidence, often because, very basic things. You can't even identify who actually fired the shot. This was an internal armed conflict. There was a counterinsurgency campaign taking place. The basis of these civil claims, as ridiculous as it sounds, was often 2 lines. A person would make a complaint to a private law firm called Public Interest Lawyers. We'll get on to that because Public Interest Lawyers, a law firm that's now defunct, the senior partner of that firm was struck off, disbarred for dishonesty this year. He was the author of many of these complaints. That's created other significant problems for us. But as I say, 70% of these claims have been dismissed, and most of them really because you can't even launch any kind of criminal investigation on the back of the complaint that's been made. It's so vague. Not to say that there are serious matters that need to be looked at, and I'll come on to that in a moment. So the Iraq Historic Allegations Team, you see that on the left, was established by the government in 2010 because there were these growing numbers of claims that were being made. The government became concerned, so they saw the need to set up a specialist investigative team, and this was 3 years before I was appointed. So its mandate was to review and investigate allegations of ill treatment during Optelic between 2008 and 2009. Optelic was the British name for the operation in Iraq. The mandate of IHAT, of the Iraq Historic Allegations Team at the beginning, was just to look at allegations of abuse. So Iraqis who'd been taken into custody by UK forces and alleged that they had been tortured or ill-treated or abused. That mandate expanded to include homicides when we were receiving a significant number of allegations that UK forces had killed Iraqi citizens in Iraq. It was originally approximately 150 people, civilian investigators, analysts, and the Royal Naval Police. We couldn't include the Royal Military Police who police our army because many of them had been involved in the original investigations back in Iraq in 2003 and 2004, and the Divisional Court in the UK said you can't involve these people because they've already been involved and there may be a perception that they're not dealing with things in a completely honest and open manner. And the whole of this operation was under the supervision of the Chief Police Officer for the Navy. When I arrived in 2013, I set up an operational offences team because at the time we were dealing with this work on an ad hoc basis, and I felt the need that we needed to be seen to be doing it properly. We needed a separate team of prosecutors. I was fortunate to be able to call on all of my experience in the international courts, so I set up a discrete team of prosecutors at the SPA. I was mindful of the fact that I had army prosecutors working for me who'd been advising the chain of command on the ground in Iraq beforehand, where a lot of these cases, particularly involving homicides, had never been investigated because they'd been switched off for various reasons. It was a combat killing, so it was somebody that was killed in combat with the armed forces. And I felt because army lawyers in my organisation had been advising the chain of command on the ground, I had to basically conflict them out of all of this advice, and I brought in naval and air force prosecutors and 4 civilian prosecutors from our civilian prosecuting service. All of them are directly accountable to me, and within the chain of command I report to the Attorney General of England and Wales, who essentially supervises my work in this field. So this was the system that I set up to deal with this. And I know it is unbelievably complex, but there are legal reasons for this. Much of what we're doing here it's not just answering to the International Criminal Court, it's also answering to the Divisional Court. So if you look in the top left-hand corner, we get an allegation. And as I've said to you, often the allegations are very thin. It's a couple of lines. So what I put in place was a pre-investigation assessment. Is there a prospect that we can actually investigate this case? Have we got enough evidence to go on all these years later? Do we have enough information to even launch an investigation? Now, oftentimes at that stage the answer is no. We don't have enough information to carry out any form of investigation at all. Now, where there is sufficient information, a fairly hefty report is put together. Legal advice is given by my organisation, and then we have what's called a joint case review panel with the Iraq Historic Allegations Team, where lawyers and investigators work together. Again, this was something that I could bring from my international experience. The civilian police within the UK were not used to it, but it was a way very quickly of going to focused inquiries. So we would do focused inquiries where it might be a very serious allegation like rape, but there wasn't much evidence. But we needed to do something just to make sure that we couldn't go anywhere with this case, or maybe we could. So that was one option, focused inquiries. The other option was a full investigation that you can see there. That was agreed between the Service Prosecuting Authority and the Iraq Historic Allegations Team. JISD next to it. Again, because of issues that I'd had in the past of working with the police, I committed everything to a document. Everything we agreed to do was in a joint investigative strategy document where the lawyers, I signed off on it, and the senior police officer signed off on it. It goes to a full investigation. EST stands for Evidential Sufficiency Test. That's a test that the police apply. If there is sufficient evidence to refer it to the Director of Prosecutions, it comes to me. If not, it's discontinued. There's a statutory obligation with very serious offence that if the police discontinue a case, they have to consult with me. I can send it back if I think it should be investigated, or if not, it's discontinued. If it's referred to the IHAT, if it's referred to the Iraq Historic Allegations Prosecutions Team, it's then for me and my lawyers to decide whether there's an RPOC, a realistic prospect of conviction. That's the test in English law. A jury, a military board, properly directed by a judge, is more likely than not to convict on the basis of the evidence. If the answer to that question is yes, we prosecute. If the answer to that question is no, we discontinue. Now, any decision that I make is subject to two forms of review. First of all, under our system, because of European Union law, victims have a right of review. So if I decide not to prosecute a case, a victim can say, well, actually, I don't agree with what you've decided. You need to get another lawyer to look at this to decide whether or not to prosecute. As I say, that's a European Union directive, not very popular amongst many things with the European Union at the moment in the UK. But nevertheless, that is a process that we have to go through. I'm also subject to judicial review by the Divisional Court. So my decisions can be judicially reviewed. So actually, in fact, you can see the decisions that I'm making are subject to a great deal more external scrutiny than any of the international courts I've worked in. And in fact, I had been judicially reviewed in one case already. Now, furthermore, there is this organisation, the Iraq Fatality Investigation, and this was set up by the Divisional Court in the UK in order to meet our obligations under the European Convention on Human Rights in terms of Article 1 rights, right to life, a proper investigation into homicides. And the European Court of Human Rights has decided in order to do that, you need to involve the victims. There needs to be a form of coroner's inquiry. It's a quasi, you'll be familiar in the US with a coroner's inquiry. That is a coroner's inquiry. So in a case where I decide not to prosecute, I then have to refer that through the Ministry of Defence to Sir George Newman, who's a retired High Court judge, that then reviews everything I've done and essentially produces a narrative on death, why somebody was killed. So you can see this is what we are doing in the UK. So I really, when I read in the press that people are actually questioning what we're doing, that we're actually not carrying out our duties properly, I really do question that, because this is an incredibly expensive process. It's already cost nearly £100 million. It's politically extremely unpopular. I'll get onto that in a moment. But for me, I mean, this is the kind of gold standard scrutiny in my view. Now, one thing that arose last year, which was quite helpful, all of the civil cases, all of the cases brought under the Convention rights, under the European Convention on Human Rights, have all had to have been adjourned while we carry out the criminal investigations. So all of those civil claims are sitting in the High Court in England and Wales whilst we get on and do these criminal investigations. And obviously, the High Court wants us to do that quickly. They want us to get on with it because they want to decide on the civil claims. And the Divisional Court appointed a High Court judge, another High Court judge, Sir George Leggett, to supervise the criminal and civil cases. So he acts as a kind of arbiter. I have to go and see him twice a year in court to explain where we are with everything. And last year, I got him to agree to this test because in many instances, some of these cases are simply impossible to investigate after all of these years, but because of the involvement of the ICC that we'll come to in a minute, I felt we had to do something. And I was trying to explain that to him. We've got to be seen to be doing something. But he agreed to this test. Is there a realistic prospect of obtaining sufficient evidence to charge an identifiable individual with a service offence? So in many cases, one, we couldn't identify the individual who had committed this alleged crime. And secondly, in many instances, we knew that we'd never get sufficient evidence to charge anybody. And he agreed to this test. He agreed, if you apply that test at the outset of a case, if it doesn't meet that standard, then you can switch it off and you don't need to look at it. And that saves a lot of time and a lot of money. So what are the problems? Well, The problems I think we share with all of the international courts. I don't think it's any different from that which we experienced at the ICTY. Khmer Rouge Tribunal even more so, obviously 30 years has passed. Lapse of time. So, many of these crimes took place in the early 2000s. We're dealing with Iraq, essentially a failed state, not a very secure place in which to do investigations. Unfortunately, the British Forces documentary records are not that great. We've got some of them, we haven't got all of them. Much of it was destroyed, not for any criminal reason when they left, but they just didn't take it with them. And it wasn't always stored very well electronically, but there's nothing sinister in any of that. This was practice. And these documentary records, they're not sort of records of killings of people, they're brigade records of deployment of troops, so that if you get an allegation that a crime happened in a certain place, and if you look at the brigade records, you can actually find out whether that unit was in that place at that time. Cause of death. So many of our homicides, no post-mortem was ever carried out on the body. Islamic culture, the body was buried very quickly. Oftentimes we don't know where the body was buried. We've got no ballistics to match the specific ammunition that British forces use. Very little medical evidence unless somebody was taken to a military hospital as to cause of death. Some instances we do have that, in many instances not. A lot of hearsay. A lot of Iraqi witnesses and this is an experience we've all had in the international courts, where people give an account to make it sound as if it's actually from them and they're talking about somebody else's account, what happened to them. Witness interviews have been extremely complex. We've had to move witnesses out of Iraq to Istanbul in Turkey in order to interview them. We've had all kinds of problems with immigration. You also know all the dangers and security problems on that border at the moment. That has been an extremely complex process. We've also had to be very aware of the potential sort of welfare and health problems of both suspects, and then I'm talking about British armed forces, so members of the armed forces with post-traumatic stress disorder who have gone to the press and made complaint that they're the victim of a witch hunt. Then we've got problems with witnesses who are suffering from mental health issues, so we've had to bring in psychologists to actually sort of proof these people in advance to make sure that they can actually give evidence. Those mental health issues are not always the result of the allegations that they're making against British armed forces. It's a result of their living situation and actually living through a war in that country. So the preliminary examination by the International Criminal Court. For the students at the back, this is a preliminary process that the court engages in essence, to decide whether or not it's going to exercise its jurisdiction. Now, in 2006, the ICC prosecutor decided not to seek authorization to investigate allegations against UK forces in Iraq. So complaint had previously been made to the International Criminal Court that the UK was not investigating and prosecuting these crimes. They looked at it, and they did actually find, the court at the time found that there was the prospect, there was the possibility that war crimes had been committed, but that the nature of the allegations and the number of allegations were not serious enough for the court to deal with. For the court to intervene in any situation, it has to meet what's called a gravity threshold. The court only deals with the most serious crimes. And in that instance, it was felt it isn't serious enough. Yes, possibility of war crimes. No, not serious enough. Switch it off. 10th February 2014, two bodies made further complaint. The European Centre on Constitutional and Human Rights out of Berlin and Public Interest Lawyers, which is now a defunct law firm in the UK. They again went to the ICC and said, actually, there were war crimes committed, many more than was first alleged in 2006, and what's more, the UK isn't doing anything about it. In May of 2014, the prosecutor announced a decision to reopen the preliminary examination, and then in August of last year, and I'll talk about this in a bit more detail, Phil Shiner, who was the managing partner of Public Interest Lawyers, was to face charges before the Solicitors Regulatory Authority for dishonesty and also possible criminal charges. In fact, he is being investigated by the National Crime Agency. Now, the essence of what he did, as I've said, he is essentially the provider of most of the complaints that we are dealing with. And it has transpired, it's a long story, but in essence, I mean, the press will tell you that the government basically went after him, that in fact the UK government pushed the Solicitors Regulatory Authority, which is like your bar standards, I mean, it's like the Bar Standards Board for barristers. It's the organisation that regulates conduct of lawyers. The allegation in the press was that the government pushed it. Actually, the government did provide evidence, not me, the Ministry of Defence, but it was investigated independently, and it was found, unfortunately, that he'd been paying off witnesses that were making complaint. Now, oddly, they were paying off witnesses, some of whom were speaking the truth about what had happened. So you can imagine how enormously damaging that is for the work that we're trying to do. Now, interestingly, the case in which that was found is a case called Al-Swedi. The events in that case are not directly linked to what I'm dealing with, but the problem is that the interlocutors, the individuals that he was using in country to contact witnesses in that case where there was found to be dishonesty, are the same interlocutors that he was using in many instances in the case that I'm looking at. So you can imagine what defence lawyers are going to say in any case. You know, if people were being paid in that case, what's to suggest they weren't being paid in that case? So on the 2nd of February, Phil Shiner was struck off by the Solicitors Disciplinary Tribunal, as I say, for professional misconduct. They found, interestingly, the tribunal to the criminal standard that he'd been dishonest when representing claims by Iraqis against British soldiers. And as I said, the vast majority of the allegations against British forces in Iraq, they've been brought through his law firm. And that's, you know, and it was also those allegations that in large part caused the International Criminal Court to reopen the preliminary examination. Now, obviously, we've had discussions with the International Criminal Court. They are well aware of all of this information. You know, they are concerned about it too. We have had, in fact, a very positive outcome in all of this. I mean, this is a huge problem that I'm now dealing with, because we're now having to go through cases and try and work out where we can actually exclude the involvement of this firm of lawyers, public interest lawyers, so that we can try and get rid of the taint, and there aren't many, actually. But our relationship with the International Criminal Court has been extremely constructive. And I attended a conference actually at the end of June in The Hague, where there were a number of individuals, including human rights bodies, that were very critical of the ICC and the manner in which these preliminary examinations are conducted. But actually, for me, I've found it a very, very constructive process. It's also, you know, I use the word handrail. It gave me a handrail at the time to go to ministers who were getting they were basically worried about a lot of very negative media around this, because many members of the UK Armed Forces were looking at this process and saying, actually, you know, it's a witch hunt. There were many of them suffering from post-traumatic stress disorder. There was a Defence Select Committee. Our UK Parliament had an inquiry into all of this that I'll talk about in a moment, and they were extremely critical, this parliamentary committee of the Iraq Historic Allegations team. So the Armed Forces really ramped up their intervention with Parliament and ministers, and basically got a lot of politicians on their side. So ministers within the Ministry of Defence and the Attorney General were getting very nervous about this. And one of the things that I was saying to them was, look, you've got to do this. Because if you don't do this, the International Criminal Court, they could intervene. It's unlikely, but they might. And if we are seen to be making decisions based on politics, however unpopular all of this is, that is a very bad thing. That is going to put the UK in an extremely bad place. So that has been extremely useful for me in the face of all of this, to say to people, we've got to do it. You know, not just because we are a country who respect the rule of law, but we have international treaty obligations that we have to fulfill. And we're not a country that's going to breach those obligations. This has to be done. You have to find the money, but not easy. Because, as I say, you know, the process has come in for a lot of criticism. So, as I say, in this year, it started in November of last year. It was a parliamentary committee chaired by a guy called Johnny Mercer, who's a former captain in the British Army. He had obviously spoken to a lot of the people who'd been subjected to investigation. As in all of these kinds of cases, mistakes had been made. I mean, we had one dreadful case before I arrived where a former policeman, so he was a civilian police officer. He had his warrant card, but he was retired, so it had actually expired, and he got onto a military base using an expired warrant card. Now, I know it doesn't sound that bad, but in the context of these investigations, once this parliamentary committee found out that a policeman who was retired was essentially posing as a Home Office police officer, all hell broke loose, and that became a very, very serious allegation being levelled at IHAT. There were also allegations that they'd been sort of camping outside former service persons' houses, people that they wanted to speak to who were refusing to speak to them, that they were essentially intimidating witnesses. I think a lot of this was exaggerated, but it really played to the right-wing press in the UK, and it led actually in the end to, you can see the effect of the demise of Pitt. It's not just down to them, but it's basically discredited both witnesses and the process, because politicians are now saying, well, the guy who was the principal author, he was dishonest, he was paying witnesses. How do you know that this process has integrity any longer? Well, we're doing our best to make sure it does. It's had a significant detrimental effect on the test. Is there a realistic prospect of gathering sufficient evidence to charge an identifiable individual with a service offence? It has had a very negative effect on that, because a lot of our evidence has been generally discredited by the dishonesty. The Iraq Historic Allegations team was closed at the end of June by the Minister of Defence, Sir Michael Fallon. There is a residual body that's been set up, the Service Police Legacy Investigation. It's just basically rebranded because the IHAT brand is so toxic, so we've had to rebrand it as something else and to let go a lot of the senior civilian police officers who were in the IHAT organisation, which is a shame, because these were people who were very, very good police officers and knew all the cases. So we've got a new body with a few of those people left, but mostly naval policemen, and we're trying to sort of build that team up to finish the work. Now, the remaining cases, and there's about 50 of them, some of which are very serious and need to be addressed. And just to sort of put this in some kind of realistic perspective so that it doesn't seem that all of this is a waste of time, in 2003-2004, a case was brought before the courts involving a man called Baha Musa, who was a hotel receptionist in Iraq who'd been arrested by UK forces upon the basis that he was suspected of being involved in insurgency, and he was beaten to death in British custody. I did have the photographs, but I didn't put them up because I thought that there might be young people present. I didn't particularly want to shock people as to what Now, that was that crime, I think, was one of very few that was committed by UK forces. But this poor man was beaten to death in the custody of British forces. There was a trial before my time in, I think, 2006, 2007, in which everybody was acquitted, apart from one individual who pleaded guilty, and not to actually a homicide offence, but to a lesser offence involving another victim in the case who wasn't killed. So there are serious cases. Another case I was talking to somebody about yesterday, which I'm in the process of making a decision on at the moment. At the end of the conflict, the British, like the US, were involved in trying to regenerate the infrastructure. So they would be trying to repair power stations, because obviously the power, all these power stations were damaged during the conflict, and our engineers were going in, our army engineers were going and trying to fix these facilities, and in the process they were using a lot of quite expensive material like copper wire, and there were Iraqis who had a habit of going in and stealing this and selling it because people are poor. And one of the techniques that the British were using at the time was something called wetting, whereby if they caught somebody doing this, because law and order had broken down completely, they would throw them in the Shatt al-Arab Canal, hopefully just warning them off. They'd swim to the other side, get out, and hopefully that might deter people from stealing property in the future. Now, on this particular occasion, they found two 16-year-old boys doing this. The allegation is they threw one in and then threw another one in, and the second one was screaming in Arabic, I can't swim. And one of the officers actually spoke Arabic, and he sunk to the bottom of the canal like a stone. They did jump in. British Armed Forces that were there to try and rescue him, but it was too late and he died. Now, that was a case that I thought we might be able to prosecute this case for manslaughter, unlawful act manslaughter, second-degree murder. They didn't intend to kill him, but they performed an unlawful act that led to his death. I thought it could be manslaughter. Now, interestingly, when we went to interview the Iraqi witnesses, they're absolutely at sixes and sevens with each other. I mean, they all tell different stories of what happened. You've got Iraqi witnesses saying they jumped in. You've got Iraqi witnesses saying that they were pushed in. You've got other Iraqi witnesses saying, well, that Iraqi witness can't have seen that because he wasn't there, and I was there, and this is what I saw. Now, the difficulty with that in a domestic trial is you're going to end up with an acquittal, particularly in front of a military board, where everybody is contradicting each other as to what took place. And that is a fundamental difficulty that we have in these cases, is getting reliable evidence from Iraqis and obviously most of the UK armed forces. If they are advised by their lawyers to stay silent and say nothing, which is what happened in this case, they say absolutely nothing. So all you have is a group of Iraqi witnesses who actually can't tell a consistent story and all contradict each other as to what happened. So, that's a sort of microcosm of the problems that we have. As I've said, we have an obligation to go on doing this until it's complete. I hope that we will be done with all of this by the end of 2019. The preliminary examination by the International Criminal Court remains open. No secret, we've made representations to the prosecutor to bring it to a conclusion. Obviously, the government doesn't like it that we're under a preliminary examination. In some respects, it's embarrassing for a country like the United Kingdom. I've told ministers again, look, just be easy about it. We get on with this, we do our job, we keep our records, we can show them everything that we've done. The prosecutor will close it when she's ready to close it. It doesn't really affect what we do because we'll go on doing what we are doing. I had hoped to complete the work by the end of my 5-year term, which is at the end of next year, but I suspect that it will go on for another year. Anyway, that's, I think, probably all I should say. So if there are any questions, I'm happy to answer them. Questions? Yeah, no.
If it wasn't for this work that you're involved in, that you described, what would be the amount of time that you would be involved in other types of domestic work? And do you have the opportunity to do that, or is most of your time actually brought you back into the field of what is essentially international work?
You may want to repeat the question for those.
I was asked the question. So the Service Prosecuting Authority doesn't just deal with this work. It deals with all serious criminal offences committed by members of the Army, the Navy and the Air Force. More minor offences are dealt with at what's called a summary level by commanding officers. So, for example, if a soldier fails to turn up for a duty, he's dealt with by his commanding officer. If he commits murder, it's dealt with by my organisation. So we have all that work, the day-to-day diet of the Service Prosecuting Authority alongside this work. I probably spend about 50% of my time doing this international work, mainly because it's politically much more sensitive than all of the other work that I do, where I don't really get asked so much by people in the government as to what is going on. I mean, when I say that, I want to emphasise I'm independent. It's mostly the Attorney General who asks me these questions, and he has the obligation because he has to report to the Cabinet on these things. So I spend probably 50% of my time on this work and 50% of my time on the other work, on the general diet of the SPA. It's not ideal, to be honest, but as I say, I do that because of the sensitivity of this work and the fact that it's always in the press. It's always in the press. And the press is not very friendly about this work. That was the interesting thing I thought this morning. Still in the international field, there's a lot of moral imperative. There's a sense of, what people say, doing God's work in the law. I am seen as the devil in all of this, because our armed forces are immensely respected. Historically, they always have been. They have a very central role in our society, not in government. I mean, I'm not saying that. They don't, but they're very well respected, and they've managed to generate a narrative that's made politicians, including the Prime Minister herself, extremely sympathetic to their plight. So this is very unpopular work. Yeah. Sorry. There's a. Yeah.
You spoke about how PTSD is used as a defense. Can you just speak more about how that impacts your cases and what you have to do to counteract or work with that?
Yeah. I mean, I think in a sense it applies to two groups of people. It applies to service personnel, and it applies to victims. And I can actually talk about a case, quite an interesting case, where this arose. So as far as the victims are concerned, we know that there are mental health issues with many of the witnesses that we speak to in Istanbul, and obviously we want to make sure that they can give as credible account as they possibly can. So we have a psychologist who comes with us and interviews the witness in advance and warns us of any problems that individual might have in actually speaking to the truth of events. And I suspect the ICC probably does, yeah. So for Fabrizio's conveyed, the ICC do that now too with many of the victims. I mean, you have to, really, to look as if you're doing things responsibly. So that's on the one side. And then on the other side, you've got it with the service personnel who are the suspects, who are people who have the allegations made against them. And we actually have a very interesting example of a case which is an astonishing outcome, but here it is. I'll be quick because I know there's not much time. It was a case involving Sergeant Blackman, who was a Marine who murdered a member of the Taliban in Afghanistan. So it wasn't in Iraq, it was in Afghanistan. And it was the clearest case I've ever seen, where they had head cams, so they were video recording what was going on. And basically, to cut a long story short, it was an injured member of the Taliban, so an injured combatant. He was still alive. He'd been shot many times by a helicopter gunship, with a chain gun. So he was full of rounds, but he was alive, and you could see on the video his eyes were flickering, he was moving, he was alive. And essentially Blackman and his patrol of Marines came across this guy, and they talk amongst themselves who's going to give first aid. They do a lot of swearing, and then basically Blackman pulls his sidearm from a chest holster, and he turns around to the soldiers, the Marines with him, and said, "I'm about to break the Geneva Conventions, guys, so don't tell anybody." He puts the pistol up against it, and he fires a round into the guy's chest, and he dies. And he was convicted of murder at court-martial. It went to the Court of Appeal. In our system, life is never life. It's a determinative sentence. So he was originally, I think, given 10 years, which is quite a light sentence because there was a lot of evidence that he had mental health issues, and then that was reduced to 8. And then it came back via a circuitous route, a review. We have the Criminal Case Review Commission, which reviews convictions. They sent it back to the Court of Appeal this year, and basically the court found that his mental health was such that he couldn't be guilty of murder. It had to be reduced to diminished responsibility manslaughter. So, in other words, he wasn't thinking straight when he did all of this. Now, the interesting thing in the case is that I know in the first instance trial that he was actually offered that route by his defence lawyers, that, look, you could get a report that says effectively that your mental health was at such a level that you can't be responsible for murder. You couldn't have had the intent. It's manslaughter by reason of diminished responsibility mental health. And he rejected that at trial. He didn't want to adopt that defence. And then later, in the second appeal, our appeals court accepted that in fact he could now claim that route through to manslaughter from murder. And a lot of that was because the media was so behind him. I mean, he had the author of The Day of the Jackal, Frederick Forsyth, who's a big, he donated £2 million to the appeal. All of the tabloid press, the Daily Mail, the Sun, were all completely against us, against the prosecution. And we fought it. I mean, we challenged the medical evidence that was presented in court. There was also some information that the defense lawyer involved, a guy called Jonathan Goldberg, had, I wouldn't say orchestrated the medical evidence, but he had, a lot of influence was placed on the psychiatrists that were involved. And you could see that from the email correspondence that was going on, that we were obviously all a party to, because we had 3 psychiatrists, and in the end they had to agree. The Court of Appeal required them to agree a report that was then presented to the Court of Appeal judges, who then eventually decided, actually, yeah, this is diminished responsibility. But that was a case, without a doubt, even in a country like the UK, where we do have independent judges, you could see the pressure these judges were under from a media that was very sympathetic. Now, to be honest with you, Blackman is no danger to the public. I mean, he shot this guy and killed him. He's perfectly safe. He's now out living with his wife down in the West Country in England. But to me, that wasn't the point. The point was, even though it was a member of the Taliban, a so-called terrorist, that was an injured combatant. And he shot him and he killed him, and he shouldn't have done that. He should have put him on a helicopter and sent him for medical help, and he didn't do it. Now, the guy might have died in hospital, but again, that's not the point. He hastened his death.
Wow, thank you very much, Andrew. And of course, our theme this year is other opportunities on accountability and justice, aside from international criminal courts. And so, Andrew, thank you very, very much. That was a tremendous presentation. Thank you.